Unfortunately, many catastrophically injured people are the victims of this clearly preventable crime. And because it's a crime, you will need to work as a victim with the district attorney's office. The district attorney will prosecute the crime for the state. The defendants will often plead the Fifth Amendment, which means they're not going to answer questions that may incriminate them. That and the pending criminal prosecution is going to prevent the victim or the victim's family from getting information they need and want. You need to work closely with the district attorney's office or the victim advocacy office. In fact, MAD Georgia has a victim advocacy program that will help you stay informed and know what's going on with the criminal prosecution. Driving under influence also gives rise to punitive damages. Punitive damages are those damages that are given to deter or punish the conduct. They are different than compensatory damages, which are meant to compensate the injured party for the harm done. The Georgia General Assembly has set the cap for punitive damages at $250,000. However, that cap does not apply to DUI cases. What's important to understand when prosecuting a civil DUI case is that evidence is needed both from the criminal prosecution and your own investigation. For example, the GBI will do the toxicology test. Other evidence will be where the impaired driver was drinking. That may give rise to what's called a Dram shop or social host liability case. Dram shop and social host liability is a situation where the person who provided the alcohol may also be held liable in addition to the impaired driver. Now, the Georgia General Assembly has decided that it's the consumption of alcohol, not the serving of alcohol, that is the primary proximate cause of impaired driving. Under certain circumstances, the provider of alcohol, the Dram shop provider, either a bar or restaurant, may be held liable. These circumstances are that if the impaired driver is noticeably intoxicated and the provider knew that that impaired driver would soon be operating a vehicle, then the social host, the bar, the restaurant may be held responsible in those circumstances. As for underage consumption, there is a strict liability criteria. That is, if a provider serves alcohol to an underage drinker, then they may be held liable regardless of whether the underage drinker seemed intoxicated if that results in their impaired driving causing harm to your loved one.